Does the Vice President cease from becoming such the moment she assumes the position of Secretary of Education?
Madam Chair, she does not cease, but then she holds another office separate from the office of the Vice President. And the Constitution is clear. In fact, it's only the President, Vice President, the Supreme Court. In fact, the very purpose of impeachment is to remove these high officials. In fact, the Secretary of Education, she resigned already. How can we proceed with hearing allegations on the Secretary of Education?
Madam Chair.
No, Madam Chair. So therefore, yes, let's hear also our distinguished Chairman Benny Abante.
This is not to impeach. This committee is not to impeach. Gusto ko pong i-correct yan sapagkat ba sabihin ng taong bayan na tayo rito, nagkakaisang impeach na ang Vice President. This is to hear the impeachment complaint, Madam Chair.
Of facts na inugnay ko nga po doon sa mga constitutional offenses supposedly committed. Thank you.
Section 2 of Article 11 enumerates the officials that will be impeached. I cannot see here the Secretary of DepEd to be impeached. In other words, Madam Chair, these allegations about actuations of Vice President Sara as a duly appointed Secretary of Education is not within the jurisdiction of an impeachment court. We're not impeaching here a Secretary of Education.
Second day nga ho dyan sa Committee on Justice kung saan mga kaadita sa kumpakapalan na lang ho talaga ng pagmumuka. Number 1 na ho yang si Laila de Lima. Mantakin po ninyo mga kaadita, naghahain ho siya ng betrayal of public trust, graft and corruption dito nga sa 125 confidential funds netong si BP Sara. Bakit noong ilang buwan pa lamang huy nakaraan mga ka-update o yung nakalipas, noong ini-impeach si Marcos Jr. hindi ho siya nagsasalita, no comment ho siya dyan. Bakit dito ho sa 125 million mga ka-update, nabutata ho siya, ayan dyan ho kay Congressman Rodriguez. Sinupalpal ho siya na hindi ho niya pwedeng kasuhan dahil isa hoong Secretary Education ito si BP Sara noong mga kapanahunang iyon. Hindi lang ho yan si De Lima ang nasupalpal, pati ho si Luistro mga kapatid, nakatikim ho ng matindihong rebat dito kay Kong Rodriguez. Kaya mga kapatid, hindi lang ho yang si De Lima ito nasupalpal, pati ho itong si Luistro. Kaya mga kapatid, kahit na chair yan si Luistro, hindi ho siya umabra. Hindi ho umubra dito kay Kong Rodriguez. Pati ho ito pa lang si mga kapatid, hindi lang itong si De Lima, si Luistro, pati huy sila Joel Chua, nakatikim ho ng matinding rebat dito kay Kong Rodriguez. Kaya mga kabdita, ito pa, hindi lang yan mga kabdita, pati pala si Benny Boy Dila. Mukhang naghuhugas kamay na. Kasi mantakin po ninyo, nasabi niya na baka sabihin daw ho ng mamamayang Pilipino, ini-impeach lang ho si BP Sara dahil sa kanilang parang sariling interest. Ganyan ho yung pinapakita nito si Benny Boy Dila. Hanggang kahit naman na bumalik dito si Benny Boy Dila mga kapatid, wala naman na hong susuporta dyan. Diba noong isang buwan pa lamang ho atay nakakalipas, dyan din ho sa Committee on Justice, sinabi niya na hindi niya sinuportahan o susuportahan si BP Sara sa kanyang presidential election. Ganyan din ho yung nag-rebat ni BP Sara. O bakit ngayon mga kapatid nagsasalita ito si Benny Dila na ganyan na naghuhugas kamay? Kasi nga mga kapatid, nakikita niya na yung 2028 presidential election, malinis na, walang kalaban ho si BP Sara. Kaya mga kapatid, kung bago lang ho kayo sa ating channel, isang like, share, isang subscribe lamang ho. Malaking tulong na yan. React na ho tayo dito sa mga gisahan dyan sa Committee on Justice kung saan wala ho talagang umubra dito kay Congressman Rodriguez. Kaya mga date, react na ho tayo. Pasadahan na ho natin yung mga pagbabangayan at yung matinding sarswela dyan sa impeachment na inilalatago nila kay BP Sara. Kaya dito, rekta na ho tayo.
Ang notices of disallowance po ay pwede pang i-appeal ng Office of the Vice President sa regional level ng COA, sa Commission proper ng COA, at pwede pang humantong sa Supreme Court. The notices of disallowance does not presuppose guilt on the part of the Vice President. It is not tantamount to a prosecution. Kaya wag po natin itong gamitin, itong mga dokumento na ito, as if meron ng ginawang kamalian ang ating Vice Presidente dahil dito po pumapasok yung procedural due process kung ito pa'y accorded sa ating Vice Presidente. At isa pa po, yung pong mga ginawa ng Quadcom nung nakaraang taon, yung pong pagbubukas ng mga envelope, I don't think yan po ay kasama sa trabaho ng Kongreso. Dahil ang pag-audit po ay trabaho ng COA. Meron po tayong Latin legal maxim, potestas delegata non delegari. Delegated
The
power should
Honorable
not be
Marcoleta
delegated
is
further.
reminded to confine the manifestation to the subject matter of the impeachment
Opo,
proceeding.
this is pertaining to the...
This is not
the
about
envelope.
Quadcom. This is the impeachment proceeding on the 2 complaints against the Vice President. Please stick to the subject matter of this impeachment proceeding.
But the envelope, yung opening of the envelopes, hindi po ba may kinalaman?
If you have
ito?
concerns about the proceedings of Quadcom, perhaps you should address it in the other forums but not in the impeachment proceedings. The Honorable Marcoleta is so reminded
Opo,
to stick to the subject matter.
yun lang naman po, Madam Chair, notices of disallowance. Ito po ay hindi mga dokumento lamang na ito ay appealable, contestable at hindi ito nangangahulugan ng Vice Presidente ay may ginawa ng irregular dahil ito ay contestable. Yun lamang po ang aking obserbasyon. At ma'am, if I may react dun sa earlier remark made by the chair, I think I was alluded to kasi nagkaroon po ng spectacle kahapon.
The chair just adopted the manifestation of the Honorable Marcoleta yesterday during our determination of form.
Opo, yung pong I am speaking out of premonition. Actually, I am not speaking out of mere premonition. I was speaking out of experience.
But that's what the committee heard. Nevertheless, Honorable Marcoleta, this is likewise not a subject matter of this impeachment proceeding.
Opo, winawarningan ko lang po ang audience na to observe proper decorum. Wala naman po sigurong masama doon, Madam Chair, di po ba?
But of course, for as long as the public are not committing any offense inside this committee hearing, then there is no basis at all to call their attention or to even mention their name.
Okay, ma'am, pero nagkaroon po ng president kasi sa Senado. Salamat po.
Honorable De Lima, would you like to comment?
Very briefly lang po. Okay, the audit findings under the audit observation memorandum may be subject to appealable, and can still be questioned. But the fact remains that there are already evidence, there are already documentary evidence, kasama nga na po dito na naka-attach sa complaint, about those questionable disbursements, the use of confidential funds for not legal purposes, for confidential intelligence funds. So this committee, since it's scrutinizing now the very complaint before us, has the discretion and has the duty and the prerogative to do its own scrutiny and analysis of these documents, irrespective of any final COA finding. Of course, it is ideal that we should have the COA final finding, but the preliminary findings are already the red flags. The preliminary findings already show those acts constitutive of impeachable offenses. So it's not really a hindrance to this committee not to consider first those preliminary findings pending the final finding of the COA.
Let us be reminded as well that impeachment proceeding is a sui generis proceeding. This is not a criminal proceeding, neither is this an administrative nor a civil proceeding. The Honorable Zamora.
Madam Chair, with all due respect to our colleagues here, I would like to remind everyone about where we are at the stage of our proceedings. We are discussing the sufficiency of, in substance of the impeachment complaints, and as such, Rule 3, Section 5 of the House rules on impeachment proceedings state that the requirement of substance is met if there is a recital of facts constituting the offense charge and determinative of the jurisdiction of the committee. So we have to confine ourselves within the four corners of the complaint to check if there is a recital of facts which will show the nexus, as the Honorable Laila de Lima has repeatedly said, with the impeachable offenses charged. Thank you, Madam Chair.
Madam Chair.
Thank you. The Honorable Vice Chair Dumogan.
Thank you, Madam Chair. I was about to point out, we are in the determination of sufficiency in substance. And as far as ground number 1 is concerned, it had been supported by complete narration of facts and even documents.
Vice Chair, speak closer to the microphone, please.
Is completely supported by narration of facts as well as certified documents. So, as far as I am concerned, so that we give due process as being claimed, we answer it in the positive so that later on, the respondent will be given the chance to explain. Because look, the confidential fund belongs to her office, and second, with respect to the disallowance, it will be only her if she did appeal that one or she did not. Because as far as the records is concerned, this was a long time that it did happen, and when the disallowance was issued in, we do not know of any appeal that had been done by the concerned respondent, Madam Chair. Thank you, Madam Chair.
Thank you. The Honorable Arbison. Kindly turn on.
Thank you, Madam Chair. I just want to make a manifestation regarding the definition of confidential fund.
Yes.
Confidential funds are lump sum budget allocation for government agency, specifically for surveillance, intelligence gathering, and security-related activities. These funds are designed for expenses that cannot be disclosed publicly to protect national security, peace, and order. Common use to include purchasing information, renting safe houses, and conducting undercover operation. Thank you, Madam Chair.
Thank you. Would you like to comment, Honorable De Lima?
No need, Madam Chair.
The Honorable Padiernos, and then Honorable Erice, and then Honorable Degamo. Honorable Padiernos.
Thank you, Madam Chair. I just wanted to make a few comments based on the observations of all of our committee members. So as mentioned by the Honorable Zamora, at this stage, we are merely looking at if there is a recital of facts constituting the offense. So at this moment, we are not weighing evidence or proof. And we only determine whether, first, the allegations are more than mere conclusions of law. Number two, the impeachment complaints specify acts or omissions attributable to the respondent. And number three, the acts fall within the constitutional grounds for impeachment as provided for in our Constitution. So yun po yung betrayal of public trust, treason, bribery, other high crimes, and so forth. So, just to ano lang po, for the consumption of our viewers, hindi pa po natin dinedetermine dito yung guilt ng ating impeachable officer. Hindi natin sinasabi na ginawa niya yon. In fact, parang ano po yan pag nag-file tayo ng isang complaint, criminal complaint before the prosecutor. So, we are here acting as prosecutors and checking if there is probable cause, in this case, to determine whether there is, at this moment, recital of facts constituting the offense charged. At sabi nga po ni ni Honorable Dumogan, meron pa pong opportunity ang ating impeachable officer to respond to this complaint. Hindi naman po na wala na po tayong due process, kumbaga. Bibigyan po siya ng pagkakataon to defend herself in this committee. Nevertheless, gusto ko lang pong mag-make an observation. So, as to ground one, assuming the allegations as pleaded for threshold purposes, the complaint alleges large-scale misuse and conversion of confidential funds in a manner that, if true, would plausibly constitute betrayal of public trust. Of course, minention din po yung labels ng plunder, malversation, and graft, and corruption. Pero tandaan po natin, itong mga crimes na to, may mga elements po yan that is provided under the law, and especially for mga malversation which is under the RPC, may mga requirement po yan na dapat may bad faith or criminal intent versus yung plunder, which is a special law, mala prohibita po, criminal intent is not required. So what I'm trying to say is, insofar as the crimes that were alleged, medyo, sabi nga po ni Honorable Rodriguez, medyo upon perusal of the complaint, borderline po yan. Hindi natin pwedeng sabihin na pwede pong impeachable offense. Pero under betrayal of public trust, which is a catch-all phrase as given by under our jurisprudence, pwede po natin sabihin pasok eh. Pero again, we are not we're not saying here that the impeachable officer committed betrayal of public trust. We're just determining now if kapag nalaman po natin na ginawa niya to, does it constitute that impeachable offense? So yun lang po, Madam Chair. Thank you.
Thank you. If there are, would you like to comment, Honorable De Lima?
Briefly, Madam Chair.
Yes, please.
Okay. Earlier, it was mentioned that we're acting here as prosecutors to determine probable cause. Not at this stage.
Yes.
Because at this stage, it's only the sufficiency of substance, sufficiency in substance of the complaint. Now, about the fact or the observation that some of the grounds, including graft and corruption and plunder, may not, as alleged, the facts as alleged, may not fall under those, but definitely would fall under betrayal of public funds. It's betrayal of public trust. Now, it will be shown by the pieces of evidence that will be presented in proper time, that taken together, cumulatively, collectively, this can fall under those offenses or under those criminal acts of plunder and graft and bribe malversation. As I mentioned earlier, when we talk about plunder, it's a series of acts of malversation of public funds. So we will see in the course of the evidentiary hearing that taken together, yung mga maglalabas po sa mga documentary evidence, most of them are here already, and also to be backed up by testimonial evidence, would show that the elements under those acts, plunder, malversation, graft and corruption, will be sufficiently established. So evidentiary, Madam Chair.
Thank you. The chair believes that we had ample discussion already of the first ground. So with the indulgence of the members, we will be proceeding to our determination or deliberation on the second ground. Let me read.
Madam
The
Chair.
second ground,
Can I reply to...
Honorable Suntay.
Yes, can I make
This is just a determination of sufficiency in substance. Would you like to reserve your opportunity to the succeeding grounds?
Madam Chair, before proceeding, just some additional points.
Because this is your first time for this first ground. Yes, you are recognized.
I just wanted to be clear that the signing of disbursement vouchers documents are not ministerial. People actually go to jail for basically just signing disbursement documents. No? People who are in the Sandigan Bayan today for many other reasons, because they had signed disbursement financial documents. So saying that it is a ministerial is not an actual defense. No? But secondly, on the point that COA had issued AOMs and NDs and are basically appealable, this is correct. But also, the documents contained in the AOMs and the NDs, the notices of disallowances, are also the body of evidence which constitutes the basis for the proceedings that we have today. And it needs to be reiterated that impeachment proceedings operate separately, independently of administrative proceedings of the Commission on Audit. So the statement that AOMs and even NDs are essentially appealable cannot prevent impeachment proceedings to occur and proceed as it should. Very important din po yung sa usapin po ng confidential funds, yung pong nexus doon po sa confidentiality ng use, no? Nung po confidential funds at nabanggit na po, not just in this proceeding but in previous congressional proceedings, that ginamit po yung pong pondo para sa team building activities at iba pang mga bagay na hindi po pasok doon sa definition ng paggamit ng confidential funds. Yun po yung una. Pangalawa, even if we talk about an actual use of confidential funds, which is basically the rental of safe houses, supposedly to accommodate yung pong mga givers of confidential information, I think in the previous Congress's Committee on Good Government, led by Congressman Chua, it had been stated by COA that malaki po yung ginastos para sa rental po of safe houses. So I think in the records that we have, 16 million has been used for the rental of safe houses, and I think an assumption was made that in the course of 11 days, around 500,000 was used for this. So if you make an extrapolation on a day-to-day, it would be around 45,000 per day. And if you further make an extrapolation to 30 days, that should be around 1.36 million per month in rental of these particular safe house properties. And the question therefore, and we will reach that point when evidence is elicited on what types of rental properties were used, saan po yung mga safe houses na ito? Kasi if we are talking about 1.3 million a month in rental property, saan po yung mga 1.3 million po natin makikita sa mga nagpapaupa? These safe houses should be in Forbes Park. These safe houses should be in Dasmariñas Village. These safe houses should be in the most expensive condominiums in Bonifacio Global City. Pag wala ho yun doon, mga kaibigan, parang hindi ho tama rin yung pong sinasabing paggamit ng confidential funds, even if pasok po ito sa supposed tamang paggamit ng confidential funds, which is sa pagrenta po ng safe houses. Yun lamang po, Madam Chair.
Madam Chair.
Thank you. I apologize, Honorable Erice. I overlook your name here, Honorable Erice, and then Honorable Degamo, and then
Madam
we will
Chair.
proceed to the second round.
Madam Chair.
You're recognized.
Madam Chair, can I be given also a time to explain?
Honorable Abante after Honorable Degamo. Honorable Erice first.
Madam Chair, thank you. Maliwanag naman po na dito po ay dinedetermine lang natin yung sufficiency in substance. At maliwanag din naman po yung parameters sa pagdetermine ito, yun pong recital of facts with its nexus to an impeachable offense. Tingin po na-establish naman po ito at it would be prudent on the part of the committee kung yung presentation of evidences, yung mga opinions natin ay re-reserve na lang natin after na masagot yung kinocomplain nating tao, ng kinocomplain na tao, upang sa ganoon maging fair naman tayo. Di ba? So we cannot just say na 1.3 million, Forbes Park, hindi pa naman natin nakikita yung kanyang explanation. Ang ngayon po, simple lang. Sufficiency in substance. Meron naman pong recital of facts. At ito po ay konektado sa isang impeachable offense. Kaya po, siguro, we should limit that to the discussion para po maging patas. Salamat po.
Thank you. Next is Honorable Digamo.
Yes po. Madam Chair, after hearing what have been said by Kong Leila about COA findings of irregularities, mismatch between declared purpose and actual expense, testimony from staff about cash withdrawals or distribution, evidence of lack of liquidation, direct approval of the VP. These are all linked, as have been discussed, to betrayal of public trust and graft. But then we have to remember that money trails are objective and they leave records. Kaya nararapat po siya na ma-discuss further. And para po kung talagang makikita, as what Kong Padiernos have said, kung talagang makikita na merong katibayan at talagang proof, then kahit sino pa po ito, it does not necessarily mean the VP. It could be anyone na gumawa ng mga ganito at napatunayan, mananagot po talaga. So I believe there is sufficient in substance po ang ating first misuse of confidential fund. At the same time, the VP will be given the chance to defend herself, maklear niya kung may mga pagkakamali sa mga allegations na ito. Salamat po.
For the guidance of the members, we're still on the deliberation of the first ground. So for the last Kong to manifest, the Honorable Abante. After this, we will proceed to the second ground.
I just heard, Madam Chair, my dear colleagues, the statement outlining the definition of the confidential fund. I would like to remind my colleagues that tulad po ng sinasabi that public office as public trust. Ano po? I also would like to remind everyone that public money is also a public trust. So, ibig sabihin yan, confidential funds are not exempt from accountability. Oho, di ba? Confidential funds are not free money just to be spent by any impeachable official any way he wants or she wants. They are still public funds, subject to law, subject to audit rules, and accountability. I'd like to remind everyone that we are not trying to determine criminal liability here. We are not the court. We are an impeachment agency here. So when a high official uses public office to subvert the public interest or to place personal or partisan ends above constitutional duty, impeachment is the appropriate constitutional remedy. Yun lang po ang gusto kong sabihin, Madam Chair.
Thank you. So with the indulgence of the members, that concludes our deliberation on the first ground. We are now proceeding to the second ground. Please allow the chair to read. Vice President Duterte committed culpable violation of the Constitution and betrayed the public trust by committing plunder and or malversation, graft and corruption and other high crimes in amassing and converting the amount of not less than 112,500,000 pesos from the confidential funds allocated to the Department of Education for the year 2023. Honorable De Lima, your manifestation.
Thank you, Madam Chair. For the second ground, it focuses specifically on the Department of Education's confidential funds. Katulad po nung kanina sa presentation on the first ground, ay ilalahad muna ho namin, papakita muna namin yung mga certain factual averments in relation to ground 2 before I make a discussion on why they are impeachable offenses. So ang kwento po, ang nakalagay po sa complaint, nabigyan ng 150 million na confidential funds ang DepEd. Hindi ito pangkaraniwang alokasyon para sa ahensyang ang mandato ay edukasyon, hindi intelligence gathering. Ayon sa mga alegasyon, ginamit ang kaparehong pamamaraan ng paggamit sa OVP. Katulad ng pagsacertify na ang confidential funds ay ginamit umano sa mga kailangan at legal na layunin. That's paragraph 76, annexes Rs and series. Inaprubahan at sinumite ang accomplishment reports na nag-a-itemize ng supposed expenditures. That's paragraph 76, annexes S series. At yung personal na mag-certify ng mga liquidation reports. Subalit nagpalabas ang COA Intelligence and Confidential Funds Audit Office, yung ICFO, ng Audit Observation Memorandum, AOM, dahil sa kabiguang magsumiti ng wastong documentary evidence of payments alinsunod sa Joint Circular number 2015-01. So that is paragraph 78, Annex T. Bilang tugon, nagsumite ang DepEd ng certifications mula sa Philippine Army upang bigyan katwiran ang 15.540 million na ginamit umano sa youth leadership summits. That's paragraph 7980. Pero mariin itong tinanggi ng Philippine Army. That's paragraph 81, annexes U and V series. Sa masusing pagsusuri, lumitaw ang seryosong irregularidad sa dokumentasyon, katulad din nung sa OVP confidential funds. So paragraph 85, and supported by annexes W to Z, mga payee na may hindi mabasa o kulang na pangalan, mga resibo na inilabas sa magkakaibang lugar sa loob ng isang araw ng isang disbursing officer, magkakaparehong sulat kamay o pirma na ginamit ng iba't ibang individual. Hindi bababa sa 43,249,800 ang ipinamahagi sa 677 katao, kung saan 405 sa kanila ay walang PSA birth or death records. That's paragraph 86. Isa sa kanila, si Alice Crescencio, ay paulit-ulit na nakatanggap ng pondo gamit ang iba't ibang pirma, pangalan na lumitaw din sa mga resibo ng OVP. That's paragraph 86, annexes A at BB. Higit pang nakakabahala, nag-certify ang DepEd SDO Fajarda na personal niyang naipamahagi ang mga pondong ito sa iba't ibang lokalidad sa loob ng isang araw. Isa lang araw. Isang pisikal na imposibilidad at kalaunan ay umamin na ang pondo ay inilabas sa pamamagitan ni Colonel Nolasco. So si Colonel Nolasco na naman po ito ay umano'y ayon sa utos na VP. That's paragraph 88. So, given those essential facts, ultimate facts, and mas detalyado po yung nakita ninyo sa screen, if admitted as true, these pleaded facts under the second ground constitute diversion of appropriated funds, simulated liquidation, misuse of confidential funds, and betrayal of public trust. That satisfies sufficiency in substance for the second ground. Itahi ko po muli doon sa mga grounds, yung culpable violation of the Constitution, graft and corruption, other high crimes, and betrayal of public trust. These are the constitutional offenses alleged under this second ground. On culpable violation of the Constitution, kung ipagpapalagay na totoo ang paggamit ng confidential funds lampas sa mandato ng batas, kalakip ang umano'y peking dokumentasyon simulated liquidation at pag-iwas sa COA accountability mechanisms. Isang malinaw na modus ay hindi simpleng administrative lapse. Ito ay sinasadya at may kamalayang paglabag sa fiduciary duty na itinatadhana ng Article 11, Section 1 ng Konstitusyon. Ang public office ay public trust. Under the same standard applied in Ground 1, culpable violation is sufficiently pleaded. How about graft and corruption? Tulad din po ng nabanggit kanina sa Ground 1, ang paggamit ng pondo ay paraang taliwas sa mandato ng batas, ang mga pekeng dokumentasyon, hindi makatotohanang detalye sa paggamit ng pondo, at ang pag-iwas sa mga mekanismo ng accountability kung mapapatunayang totoo ay malinaw na paglabag sa batas ukol sa tamang paggamit ng pera ng bayan. That is graft and corruption. This sufficiently invokes graft and corruption. Other high crimes. Sabi ko nga po kanina, ang other high crimes ay tumutukoy sa mga gawaing may matinding epekto na maayos na paggana ng pamahalaan. Ang sistematikong paggamit ng modus na ito ay nagpapakita ng pattern ng pagbaliwala sa batas na sumisira sa tiwala sa mataas na katungkulan. Ang ganitong asal ay isang act that renders a public official unworthy to remain in office. My position, Madam Chair, is that such conduct falls within other high crimes. And now, betrayal of public trust. Malinaw po na ang pagwawaldas sa confidential funds ay napakalaking kasalanan sa taong bayan na pinanggagalingan ng kaban ng bayan. Kung matunayan na ang pinuno ng isang ahensya ay involved sa modus na ito, malinaw na pagwawalang bahala ito sa tungkulin na gamitin ng tapat ang pera ng bayan. Ang ganitong paglabag sa tiwala ng publiko ay nagpapakita na hindi na siya karapat-dapat manatili sa katungkulan. So again, the second ground sufficiently meets the requirement of sufficient in substance, given those narration of facts na inugnay ko nga po doon sa mga constitutional offenses supposedly committed. Thank you.
To start our deliberation, we recognize the Honorable Rodriguez.
Thank you, Madam Chairman. Ground number 2 is totally outside the jurisdiction of this impeachment court. Section 2 of Article 11 enumerates the officials that will be impeached. I cannot see here the Secretary of DepEd to be impeached. In other words, Madam Chair, these allegations about actuations of Vice President Sara as a duly appointed Secretary of Education is not within the jurisdiction of an impeachment court. We're not impeaching here a Secretary of Education. In fact, Madam Chair, it is very clear that once you are able to, we'll see there are some grounds of the Vice President to be able to be tried in the Senate. It is only removal from office of the Vice President and perpetual disqualification. In the case of the second ground, specifically, it talks about actions of the confidential funds in the Department of Education. Madam Chair, the Executive Order 292 of the late President Cory Aquino under his legislative powers in 1987 provides that the office of the Vice President is totally different from the office of the Secretary of a department. We have here, very clear, I have here, you can see here, Book 2, Distribution of Powers of Government. What does it say? Here, executive, exercise of executive power, the President. It is vested in the President. And Section 12, the Vice President also shall have the same qualification and so forth of the President, and he will be, it is he here, but it should be genders equal, may be removed from office in the same manner as the president. So this is under Book 2, Chapter 3. Now, we go to the Secretary of Education. Where is he found? It is on Book 4. Book 4 provides for the executive branch. The departments, it says here, Section 1, the executive branch shall have departments as are necessary for the functional distribution of the work of the President for the performance of function. Section 3, department proper. The department is run by the Secretary. Madam Chair, all of this will show that there is a dichotomy, a separation of the Vice President when he was appointed without need of confirmation. Then that is another duty of hers. And we are not here going to try the Vice President as Secretary of Education. We are only here to try his actuations in the office of the Vice President, wherein removal in case of impeachment could be ruled by the Senate. And therefore, Madam Chair, clearly, according to our rules which says, determination of substance is met when there's a recital of facts constituting the offense charge, and there is an and here, and determinative of the jurisdiction of the committee. Determinative of the jurisdiction. What is jurisdiction of our committee? Impeachment is an impeachment now committee to impeach. The charges are to impeach the Vice President as provided by our Constitution. So therefore, not only is there a lack of recital of the facts, what is important here is that this round 2 is not determinative of the jurisdiction. So everything here, from 2 up to 6, which pertains to the Secretary of Education, should be ousted and dismissed immediately for being not within the jurisdiction of this committee. Thank you, Madam Chair.
The chair wishes to raise a question to the Honorable Rodriguez.
Madam Chair.
This is for the sake of expounding our exchanges of argument. Honorable Rodriguez, does the Vice President cease from becoming such the moment she assumes the position of Secretary of Education?
Madam Chair, she does not cease, but then she holds another office separate from the office of the Vice President. And the Constitution is clear. In fact, it's only the President, Vice President, the Supreme Court. In fact, the very purpose of impeachment is to remove these high officials. In fact, the Secretary of Education, she resigned already. How can we proceed with hearing allegations on the Secretary of Education?
Madam Chair.
No, Madam Chair. So therefore, yes, let's hear also our distinguished Chairman Benny Abante.
Madam
Is this
Chair.
in line with the
Yes.
argument of
Madam
the
Chair.
Honorable Rodriguez?
Perhaps, with due respect to my good friend, Congressman Rufus, perhaps I could be able to correct the impression here. This committee is not to impeach the Vice President. It is to hear the impeachment complaint against the Vice President. This is not to impeach. This committee is not to impeach. Gusto ko pong i-correct yan sapagkat sabihin ng taong bayan na tayo rito, nagkakaisang impeach na ang Vice President. This is to hear the impeachment complaint, Madam Chair.
At this juncture, we are calling the Honorable Dilima for her comment to the manifestation of the Honorable Rodriguez.
Thank you, Madam Chair. I respectfully disagree with the main contention that the alleged acts attributed to the Vice President concurrently holding the DepEd portfolio cannot be taken cognizance of by this committee. Clear po, concurrently, in concurrent capacity. So kaya nga po, there was the bypassing of CA confirmation precisely because she is a Vice President. No need to go through the confirmation by the CA. We're talking here as one person, same person, si VP Sara, as both the Vice President and the DepEd Secretary. And we can also say that this is also part of the pattern, the scheme in those that we allege, the complainants allege to be attributable to the VP is also attributable to her in her concurrent capacity as DepEd Secretary because nga, nandyan yung modus. It's the same modus. So we cannot separate the personalities of VPs of Sara Duterte as VP and also as concurrent capacity in those years that she was DepEd Secretary. Because nga, concurrent nga, we are talking here about same person. And we need to look into what is clear to be modus, the scheme, the pattern of her irregular acts constitutive of impeachable offenses.
Thank you. Any other member? The Honorable Suntay.
Thank you, Madam Chair. I completely agree with my distinguished colleague, Congressman Rufus Rodriguez. Constitution is very clear in its enumeration of impeachable officers. And the Secretary of Education is not one of them. The actions of the Vice President as the Vice President of the Philippines is separate and distinct from her actions as Secretary of Education. But assuming for any stretch of imagination that we find the thing one and the same, the complaint alleges the exchange of money exchanging hands, but it does not allege any wrongdoing or illegal act. Kasi yung narration, sinabi lang, napunta, binigay dito. But that's the very nature of confidential funds. It's money changing hands, being distributed. And in all those narrations, we cannot simply assume na and simply conclude that the funds was actually went to the Vice President and became for her for her enjoyment. So I think that is a conclusion. Kasi doon sa narration, sinabi, napunta kay whoever, kung kani-kaninong mga tao. Kung kay VP directly, at sinasabi natin siya nagpa-withdraw, bakit kailangan pa umikot yung pera kung siya sa kanya rin pupunta? There is nothing in the complaint that states that it was used illegally. What is present is a conclusion made that it was used illegally. We cannot simply say that it went to VP Sara for her personal gain. Thank you, Madam Chair.
Madam Chair.
The Honorable
Madam Chair.
Chua.
Chair.
Honorable Chua and then Honorable Tinio. And then Honorable Abante.
Thank you, Madam Chair. This time, Madam Chair, I beg to disagree with my esteemed professor and my mentor, the Honorable Rufus Rodriguez, who happens to be my ninong also.
Your seatmate also.
And my seatmate also, my favorite seatmate. You know, the reason why I am like this is because of what he taught from me, what I gathered from the wisdom of the Honorable Rufus. Anyway, let me read, Madam Chair, what the Constitution provides with respect to the Executive Department, Article 7, Section 3, second paragraph, which provides that the Vice President may be appointed as a member of the Cabinet. Such appointment requires no confirmation. Madam Chair, if you will read this provision, it is very clear the reason why the Vice President is holding the position, a cabinet position of DepEd Secretary is because of her being elected as Vice President. And in fact, Madam Chair, the Vice President is the only cabinet member who does not need confirmation. Siya lang po nagkakaiba. Why? Because she owes it to the people for electing her as the Vice President. Yun po yung aking argumento dito. Now, bakit naman po siya? Bakit ko naman po sinasabi na dito meron pong substance? Why? Dito pong grounds number 2, makikita po natin ito sa paragraph 72 to 91 dito po sa impeachment complaint. Dito po, mababasa po natin dito, sabi po dito, ito po, kung babasahin po natin, sa paragraph 79, page 31, sabi po dito, DepEd submitted its reply to COA ICPAW AOM. In this reply, DepEd attached DEPs justifying its use of confidential fund. The most notable of these DEPs were certification issued by officials of the Philippine Army. So ano po ba to? Ito po yung certification na in-issue ng mga Philippine Army certifying, sinasabi po nila na wala po silang pondo na nakuha galing po sa DepEd contrary sa certificate na in-issue po nila dahil ito po ay hiningi ng DepEd. At kung babasahin din po natin yung paragraph 88, sinasabi po dito, Fajardo certified that he personally disbursed this amount to the different localities in a single day, a feat that is physically impossible. Fajardo later admitted that the disbursement were made through Colonel Nolasco, who was ostensibly a military aide assigned to OBP pursuant to instructions from the Vice President, Sara. Now, sino po itong si Fajardo at sino rin po itong si Acosta? Now, we are talking here of two SDOs. Ang trabaho po ng SDOs, sila po ang Special Disbursing Officer. Meaning to say, sa kanila po yung pangangalaga ng pera. Sila dapat ang nagdi-disburse, sila rin po ang dapat na nagli-liquidate. Pero dito po, sa DepEd, dito po kay Fajardo, upon the instruction of the Vice President or at that time Secretary of DepEd, yung pera po, hindi po yung SDO ang nagdi-disburse. Dahil yung buong pera po, according dito po sa complaint, ay ibinigay po kay Colonel Nolasco na wala naman pong kinalaman sa pagdi-disburse po ng pondo. That, Madam Chair, is betrayal of public trust, clearly. So, Madam Chair, I believe that we have sufficient in substance insofar as the grounds number 2 of the impeachment complaint is concerned.
Thank you, Honorable Chua. Next is the Honorable Tino.
Well, thank you, Madam Chair. This is also a rejoinder to the comments made by the Honorable Rodriguez as well. No? So, I would agree with him that the actions of Secretary of the Department of Education will not fall under the jurisdiction of the Committee on Justice when it comes to matters of impeachment. Because, of course, the Secretary of Education is not an impeachable official. However, we're not talking about just an ordinary Secretary of Education, but the Vice President appointed concurrently as the Secretary of Education. No, and so it is what is the subject of impeachment are the actions of the Vice President in her capacity as the Secretary of Education. And so therefore, I would say that such actions of the Vice President as Secretary of Education are within the jurisdiction of the Committee on Justice, and I would go further to say that as far as the third complaint is concerned, there are sufficient factual allegations to support the ground of betrayal of public trust and graft and corruption, Madam Chair.
Next is the Honorable Abante. This is on the argument of the Honorable Rodriguez that as Secretary of Department of Education, it takes away the offense outside the jurisdiction of the Justice Committee. That is the argument of the Honorable Rodriguez.
Yes, Madam Chair. Natutuwa lang ako sa binanggit ni Congressman Suntay na palaging sinusuportahan ko yan pag-eleksyon. At kahit na ganyan siya, susuportahan ko pa rin yan sa eleksyon. Pero ito po nga sabihin ko sinasabi nila, sabi si Congressman Rufus, talagang mabira, magkaibigan kami niyan eh. Nasabi po nila na distinct, di ba? Hindi pwedeng akusahan si Vice President doon sa nagastos niya sa Beliging Secretary of Education Department. Well, mabibigyan na lang po ako na ilustrasyon. Logic lang po ito. Then, ang dalawang kamay natin. For example, ito yung Vice President, ito yung Secretary of Education. Ito yung perang binigay sa Secretary of Education na kasama ng kamay ng Vice President. Ang tanong ko ito, sino ba nag-iisip? Isa lang ang utak eh. Wala namang utak yung isang kamay. Sa isang kamay. Isang utak lang po ang nagpapagana rito. Yun ang pong sabihin.
I hope everybody heard the analogy. Now it's the turn of the endorser to comment to the argument that the fact that the offense was committed as Secretary of Education, it takes away the offense outside the jurisdiction of the Justice Committee. The comment of the endorser, Honorable Dilima.
Being in a concurrent capacity does not segregate one from the other. And as mentioned earlier, under the Constitution, she's the only, official in the cabinet that to hold a simultaneous position. The VP may be appointed as a member of the cabinet, and that's why hindi nga po kailangan ang confirmation. Now, doon naman po sa sinasabing iba ang sa DepEd, iba yung sa VP. Doon sa culpable violation of the Constitution, it does not say in relation to the proper office, whether office of the VP. It does not relate that it does not relate or is not in the relation to the office proper, which is the office of the VP as VP. That is the office proper of Sara Duterte as VP. It's attached to the person, yung pagko-commit ng culpable violation of the Constitution and even betrayal of public trust, it is attached to the person and position of the impeachable officer as her acts or omissions relate to the provisions of the Constitution. So hindi dapat nagiging stricto yung pag-delineate o pag-segregate, paghihiwalay ng mga alleged acts or omissions ng isang secretary, ng isang DepEd secretary who is at the same time the VP. Because these acts or omissions, yung nandun sa detalye po under ground 2, are her acts. One person as Vice President and DepEd Secretary in concurrent capacity. Hindi ho pwedeng gano'n na kung ano lang ang ginawa bilang VP, hindi yung as DepEd Secretary, even if these are related in terms of modus, in terms of pattern, in terms of system, ay hindi na dapat cognizable by an impeachment proceeding before the House Committee. Di ho ba?
You would like to
Respond
reply?
to reply to all those who said that we have jurisdiction.
All right, because of the significance, of this argument, let's give an opportunity to Honorable Rodriguez to reply, and then for the endorser to manifest her rejoinder.
Thank you, Madam Chair. The jurisdiction of this committee acting as an impeachment committee springs from Article 11, Section 2 of the Constitution, and then Section 3 to Section to Paragraph 7 in seriatim. And clearly, it is only the actions of the Vice President. It is the only President, the Vice President, and then we have the Supreme Court and the others. So this is the distinction between them, is that there are two separate offices with two separate budgets. We determine the budget in Congress of the Vice President, and we determine also the budget of the Department of Education. So very clear that whatever stated here in ground 2 is it is not one of those that we will be discussing, because after all, in paragraph 3.7, the judgment of in case we bring this up to the Senate, is judgment in impeachment shall not extend further than removal from office. We cannot state in the decision, in our findings, that she committed violations as Secretary of Education. That is a matter, in fact, cases had been filed in the Ombudsman. Because the Vice President is not immune from suit. Although there's a question of whether the Ombudsman can suspend or dismiss a Vice President, because impeachable officials can only be removed through impeachment. That is another issue. But the point is that this impeachment court should only focus, because of the Constitution and our rules, that it should be we should have jurisdiction. It should be very clear that all these actions of the Vice President falls within, and if there's a recital of facts against the Vice President, which is sufficient in substance, it proceeds. But in this very particular ground, we are ousted of jurisdiction in this case, totally devoid of jurisdiction to be ruling on what the Secretary of Justice, Secretary of Education has done. In fact, she's already resigned. She's not anymore Secretary of DepEd. So that is what this representation has studied. We have to follow the Constitution. We have to follow our rules. Thank you, Madam Chair.
To conclude our deliberation on the second ground, we will hear the rejoinder argument of the endorser against the argument raised by the Honorable Rodriguez. Honorable Dilima.
To me, Madam Chair, it is absurd to isolate acts or omissions committed by an officer, by an impeachable officer, done in a concurrent official status or official public function, which is an adjunct or related to VP as VP. Otherwise, I can just commit violations, I can just commit offenses and skirt accountability. That simply because that's not really the office of the VP, but the office of the DepEd Secretary, but adjunct to her capacity or status as VP. I-skirt yung mga ma-i-skirt, will play around the law just so she will be absolved from the issue of impeachment or the possibility of impeachment. Because these are related. It's the same person. It's also about fitness to hold office. Kasama rin po dyan. Fitness, both as a VP and concurrent DepEd Secretary. Evil sought to be avoided and suppressed in impeachment. Principle applies to her as DepEd, the so-called mischief rule. she cannot avoid accountability when that very position as DepEd Secretary is attached or adjunct to her function or position as VP. Thank you.
Just a quick manifestation. Maiksing-maiksi lang
That
po.
rejoinder of the endorser is supposed to conclude our deliberation on the second ground.
Madam
Please
Chair.
reserve your...
I believe that my manifestation is very important. If we will follow the logic of my very good professor and dean,
Okay. So in the interest of equality and fairness, we recognize the Honorable Chua.
kung sasakyan po natin yung argumento ni Congressman Rufus Rodriguez, at ngayon po, meron pong kaso sa Office of the Ombudsman ang BP. Paano po bang may lumabas na warrant? Pwede po bang damputin ang Vice Presidente at sasabihin siya inaaresto bilang Secretary of DepEd, hindi bilang Vice President? We cannot separate the Vice President from her previous position as Secretary. Why? Because we are trading a fine line. Pwede po itong maabuso at pwede po itong magamit sa Vice Presidente bukas makalawa, maglabas ng warrant. Dahil po sa kaso niya ng pending sa Office of the Ombudsman. At sasabihin, kinakasuhan siya at pinoposasan. Dahil siya po ay Secretary ng DepEd, hindi bilang Vice President ng Republika ng Pilipinas. Yun lang po.
Thank you. So that
Madam Chair.
concludes our...
We have short manifestation in the
Is that
interest of
in line
fairness.
also with the argument of
With
Congress?
with the second ground. I
Yeah,
think it's
but is it
related.
in line with the argument of the Honorable Rodriguez
Ma'am,
about the jurisdiction of this committee over the offense committed as DepEd Secretary?
Madam Chair, let's not narrow the discussion. We're on ground 2.